Shah and another.
My Lords.
Yes.
In this matter, I appear on behalf of the appellants with my learned friend, Mr. Joshua Monroe, acting on a direct access basis on behalf of the appellants. My learned friend, Ms. Chalmers, appears with, for the respondents, the joint liquidators of Boscolo, instructed by Thrings. And my Lord, this is an appeal pursuant to permission granted by my Lord Justice Arnold on the 16th of December from the order of His Honour Judge Matthews, QC, of the 8th of August for reasons given in his reserved judgment of the 27th of July, which is a call bundle, tab 7, page 97.
Yes.
My Lords, we have envisaged timing as follows, that I shall speak until 12:35. The learned friend will then reply
Very
to...
precise.
Well, didn't descend to half minutes. My learned friend will go to 3:55 and I will then reply until 4:10. That gives us both an equal amount of time. It does leave a notional spare 5 minutes, which respectfully would say are in the gift of the court.
Thank you. Yeah.
And if I sit down before or after 12:35, then we envisage that subsequent timings will be adjusted accordingly.
Thank you.
My Lord, the meat of my submissions are, first, it was a paramount purpose of the relevant insurance policy described in the grounds of appeal. I'll come to that shortly. Second, that this purpose fed into implied terms of both the insurance policy and what I shall refer to as the design contract between Boscolo and my clients. And these in turn are the basis for our proposition at step 3 that the shared purpose of all parties was that in short, the monies should not be used for any purpose other than the purposes of the policy. I put it a little bit wider than for the paramount purpose, because although the paramount purpose is highly important, it's not the only purpose of the policy. So we don't say there's any problem about using it for other purposes of the insurance. My Lords, I have handed up 2 documents, both which my learned friend is kindly not opposingly referring you to. One is what I call a relationship chart. And the second is an extract from the grounds, because I indicated to my learned friend that there's one part of our grounds that we're not pursuing. Perhaps I just begin with that. The part of ground 2 that we are not pressing is the proposition that the appellants were to hold the insurance monies and pay them to the appellants.
Sorry, the bit I've got, the document I've got, the proposed amended, deletes all of 2.
Well,
that's
incorrect.
Yes.
I mean, in substance, it's correct. It's that the start of 3 mirrors part of the start of 2.
I see.
So what you do is you read straight on from the 3rd line.
I've got it. So okay. So 3.
So 2 effectively
becomes,
2 and 3 become joined, but I haven't changed the numbering because it would.
Yeah, no, I understand. Thank you.
Well, so that is quite an important change, because 2 was a freestanding claim for implied term, that the money would be held on trust irrespective of anything to do with the insolvency of the company. But 3 and I think before, which isn't there, but those are premised on there being, in the circumstances, knowledge of insolvency.
Correct.
Yes.
Correct. But at any rate, and in short, one of the reasons we don't pursue 2 is because we accept that there were other purposes of the policy, which included defence costs, and so, and also because in order for the monies properly to be due to the appellants, they need to establish their claim, which they haven't yet done.
Yes, but are you, as I understand this change, you're no longer contending for an implied term or an implied trust that, irrespective of the solvency position of the company, the insured, monies received from an insurer which are referable to a claim by someone else are held in trust by the insured for that person.
That's a different thing. They are held in trust, but to give effect to the purposes of the policy.
Well, then you may have gone too far in the striking out of two, then I think. If you introduced it by saying it's just to prevent a trust to pay the money, because there are other purposes of insurance.
Indeed. Well, certainly I don't intend to abandon any part of 3 or 4 as they presently stand. And if I have struck out too much in order to give effect to our...
Well, I don't think you have, but 3 and 4 are dependent, aren't they, on there being reasonable grounds to believe or suspect that Boscarlo might be insolvent?
Indeed. And that state of mind is specified in ground 4.
Yes.
And is a basis for the implication of the term in 3
Yeah.
that I'm contending for. And that hasn't been struck out.
Indeed. But, just to make my point clear, you're therefore only contending for a trust that arises if there is a reasonable ground for suspecting that the company is insolvent.
Well, it's in fact, the way I put it is the relevant state of mind is in 3, reasonable grounds to believe or suspect that Boscarlo might be unable to meet the claimant's claim in due course from its other resources. Yeah. That's the relevant state of mind, which does apply to ground 3.
Yeah.
And I hadn't thought that was, as it were, undercut by what I've taken out.
No, it's not. But I think ground 2 was a broader trust.
Well, it may have been, but
that's gone.
It's gone anyway.
Right.
And I am making my submissions on the premise of the relevant state of mind and the paramount purpose as described in ground 3.
Yeah.
So that's the proposed amended ground, or the change to the grounds of appeal. And then, my lords, the relationship chart. The reason for this and the purpose of it is just so your lordships can see on a page the sort of interrelationship between A, the parties, and B, the various documents that we rely on. So, party-wise, over at the left, we've got my clients in the box. They're clients under the design contract. Then we've got the design contract in the middle on the BIID model form. And so there's the direct contractual link between my clients and Boscarlo. And then underneath, you see the client's claim. That's made under the design contract. But then there are, we say, strong reasons to conclude that the clients over on the left, my clients, were in contemplation of both the insurance policy and self-evidently the design contract by a number of routes. And so the first route is a letter from Boscarlo of the 4th of March, which I'll be coming to. That was a quotation for the design contract. Second connection with the policy and my clients is through the design contract itself, which was on the BIID model form, which provided that there must be a policy. And then, as we'll see, the learned judge, when he considers the design contract, makes reference to what he perceives as the purposes of the insurance provision. Then the references in the model form lead us up into the BIID, and over on the left, a box that I have inserted, the interior design profession. That is one of the entities or groups which was identified as part of the purpose of the relevant clause in the BIID model form. And then we say a subset of the interior design profession are my clients. So I think it's right to say that the key document references that your lordships will need in this context are on this chart. And then the insurer is down at the bottom, Royal Sun Alliance. The policies in question, the first one, and it's the only one in the bundle, is for the policy, it's for the calendar year 2014. And this being a claims made policy, that's not actually the policy with which we're concerned, but it's common ground, I think, between the parties, that materially the terms of all successive insurances are the same, so we can work from those PI policies.
And there were presumably policies for prior years as well, were there?
I don't know, my lord, but I expect so. So, as we say in round 4, just to be up, the paramount purpose of the policy, lordships have page 24 of the bundle. Do your lordships want me to mention full bundle references, or are pages good enough?
I think pages probably good enough. We'll see how we get on. Yes.
I'm grateful. So yes, the paramount purpose, and this is the foundation really of my submission. The paramount purpose for which the insurance was compulsorily required. By compulsorily, what we mean is that it was required under the BIID terms. And the paramount purpose is last 4 lines after the passage in green and the insurance claim is paid, namely to secure that Boscolo was financially able to compensate its clients. Now, fast forwarding a little bit, I accept, of course, that was a statement made in the context of solicitors' insurance. But in my respectful submission, there is no principal basis to treat solicitors' indemnity policies as different, fundamentally different from all other kinds of professional indemnity policies. And they all fundamentally have the same purpose. And that purpose is not merely to ensure that in the event of a claim, money is paid to the insured. There's a wider purpose. I say there certainly was in this case, even if it's not in every case. And it's very important that I show your lordships how we differ from the way the learned judge dealt with this in his judgment. And his discussion on that topic begins at page 79. Under the heading Discussion General. So, professional indemnity policy generally triggered by the notification of a third-party claim, and that's so in this case, we agree. And then he deals with the Post Office and Norwich Union case. I haven't analysed for myself how this squares with the indemnity principle, the fiction that an indemnifier undertakes to hold harmless indemnified, but it doesn't matter for the purposes of this case. And the learned judge says at the end of that paragraph, no liability yet been established, indeed it may never be. Proceedings designed to do so commenced at a critical stage. Right. Now, very important paragraph 38. And now, the learned judge accepts in his first sentence that it is not impossible in English law for a professional indemnity insurance policy to be held by the insured for the benefit in some form or another of the client or clients of the insured. Well, we say, yes, it's not impossible. It is clearly possible, and in my submission is certainly ordinarily the case. Then he says the insurer might grant the policy on such terms as to constitute the insured either an agent or trustee for such client or clients. In practice, this would be unusual. And then this, with which we respectfully disagree. It is more likely that the insurer grants a policy to the insured for the insured's own benefit. But, he goes on, as clearly shows in action, the insured may decide to create a trust of the benefit of all or some of the policy for its client or clients. Or circumstances may arise in which, irrespective of the intention of the insured, the law imposes a constructive trust upon it for the benefit of the client. My lords, in that sentence, we respectfully would circle the words irrespective of, because I wouldn't necessarily accept that a constructive trust could arise irrespective of the intention of the insured. But our case is that the trust does arise out of the intention of the insured and the insurer and the beneficiary, as reflected in the implied terms which we say give effect to the paramount purpose.
So you take issue, I think, then only with the sentence, or the part of the sentence, it is more likely that the insurer grants a policy to the insured for the insured's own benefit.
And the sentence before it. In practice, this would be unusual.
What do you mean by own benefit? Or do you read the words for the insured's own benefit in a colloquial sense or in the trust sense?
I read it. I read it in the colloquial sense.
Yes.
On the basis that he's saying you take out an insurance policy for your own benefit, for your.
So you say
commercial
liability insurance is taken out for the benefit in a colloquial sense of your customers to whom you're going to owe liabilities.
It's for both of you. It's
right.
For both of you. I mean, it's clearly a benefit to an insured to be indemnified by insurance, but it's also a benefit to the client of the insured that there be a policy of insurance, because it does, to put it colloquially, at least increase the prospect that there will be funds available to meet his claim, or as it was put in the Arnold Brightman quoted in the impact finance case, to secure that the insured will be able to meet the claim of his client. Now, I say straight away, this argument simply wasn't run in Harrington. In my submission, Harrington was decided in its own way. It doesn't determine this point at all. And it was decided on the basis, bluntly, that there was no connection between the claimant and the policy, which, in my submission, is a very in my submission, it's not right there's no connection. I mean, it is the risk of claims that gives rise to the need or the wish to insure.
That was recognised in Harrington, wasn't it? Indeed, the court felt uncomfortable at reaching the decision it did because of that connection.
Well, exactly so, but having it an earlier passage said there was no connection. And absolutely, I mean, it makes uncomfortable reading for any English lawyer to see that the Court of Appeal found itself driven to such an unhappy result, as it itself felt. Now, it may be said, oh, well, it's all right now, we've got the Third-Party Rights Against Insurers Act, but that deals with a different problem. The Third-Party Rights Against Insurers Act deals with a different problem. How is the insured's claim against the insurer made in the event of an insolvency? But we don't need to make a claim against the insurer. Because
Sorry, how it deals with the problem how the insured's claim is made against the insurer? Is that what you said?
Yes.
But doesn't it simply transfer the rights of the insured to the claimants?
Yeah.
Yes.
But we're not concerned with enforcing rights against the insurer because the insurers have paid out the limit of indemnity.
Right.
So, reading on, and yes, it's quoted, your Lordship's point, it's quoted in paragraph 40 of the learned judge's judgment at paragraph 40, very reasonable and proper caution is defeated in the very case in which it's intended to be of most use. So now, the learned judge now turns to the contract, the design contract, he refers to, and he quotes the relevant provision. Your Lordships will find that at page 130 of the bundle.
Do you want us to go to that?
Yes, please. I'm going to spend a little time on this, if Your Lordships will forgive me.
Page 30, you say?
130.
Supplemental.
Yeah.
Okay.
No. So you'll see at page 131 there's a section D headed Responsibility to the Institute and the Interior Design Profession.
You said design contract. This is the code of conduct.
Absolutely, but thought. That's because it's the code of conduct.
Yes.
That the learned judge was referring to.
Okay. Yeah. Thank you. Yes.
And
D.
the learned judge draws attention to the fact that D is headed Responsibility to the Institute and the Interior Design Profession. And he draws the inference from that it wasn't intended to benefit the client. Now, we say that was wrong for a number of reasons, and I'll perhaps come to those reasons in a moment. But I just wanted you to see that that was his conclusion. And then now ask you to go back, please, to page 80.
So he deals with it at paragraph 41.
Yes.
Is that where we're looking at in the judgment?
That's where we yes, indeed. And I think I've shown you the relevant bits, the heading.
Yes.
Paragraph 2 of that, members shall carry appropriate insurance.
Yes.
To include employers' liability insurance, public liability, product liability, and professional indemnity.
And the judge draws the distinction that it's not in B.
Yes.
Yeah.
That's right. And so he reaches the conclusion, no clear indication it was intended to inure for the benefit of the clients. Indeed, the cross-heading suggests the contrary. And then he says, 42, the inclusion in the contract is explained as much by the Code of Conduct as anything else. And I should say we agree in paragraph 42 of his judgment with that sentence, and we agree with the following sentence. Policy not expressed to be for one project only or for the benefit of a particular client or clients or need for any clients. Instead, it's general policy. Companies work for all its clients on an ongoing basis, claims-made basis. Now here, he says, no trace of documents before me of any contemporaneous suggestion by the respondents they were unwilling to take the ordinary risk of dealing with a person who later became insolvent. My Lord, if that's intended to indicate that there was no evidence of any subjective intention, we respectfully submit that's irrelevant. What matters here are objective intentions. And then he goes on, it wasn't even the respondents, so far as I can see, who first proposed there should be insurance. It would be surprising if it were in a professional context. Instead, the impetus came from the Code of Conduct. It appeared as a pre-printed clause. Yes, we agree. But then his conclusion, overall, I cannot construe the contract as requiring the company to obtain insurance in which or in the proceeds of which the clients will have a proprietary interest. Now, that's really, in a sense, the end of his reasosoning about purpose. And in my submission, it is inadequate, with great respect. And these points, like I said, weren't pressed made before him. But one needs a much wider appreciation of the context of this policy than we find in paragraph 42. Now, his conclusion as to implied term follows inexorably from what he's just concluded about purpose. So he says it's not necessary to imply a term to that effect. Now, in my submission, once you conclude that there's not a purpose to benefit the client, then I respectfully accept that there can't be an implied term to the effect for which I contend. And in a sense, the learned judge's judgment illustrates the close connection between the purpose, why the insurance was required, and the implication of terms. Just for Lordship to note, the respondent's skeleton advances reasons why solicitors are to be differentiated from other professionals at paragraphs 35 to 38. That's pages 52 to 53. We needn't turn those up, but in my submission, they really mirror the judge's approach and don't take matters further.
Is there any case law which suggests that in relation to solicitors' insurance, that is held on trust for clients?
I don't know. If I knew of it, I would have cited it.
Yeah.
And no, I don't think so. So I accept that this is an attempt to build, but it's an attempt to build on what, in my submission, is a very solid foundation, namely the observations of Lord Brightman, endorsed by the Supreme Court, to the effect that it is a paramount purpose. And my Lord, in those circumstances, in my submission, a court faced with a suggestion that a term should be implied, that the proceeds of insurance should not be dealt with in a manner inconsistent with the paramount purpose, is, in my respectful submission, should be pushing at an open door. But the purpose of implied terms is to make contracts work. How can a contract, the paramount purpose of which is to secure that a client is financially able to recover, that the insured is financially able to meet valid claims, how can that purpose not be frustrated if the insured is free, in whatever circumstances may exist, to do whatever he wishes even though it gives rise to the unhappy consequence identified by Lord Atkin in the Harrington case. So, may I now ask you to go back, please, to the code at page 130. And note, without the moment looking at the detail of it, that there are sections headed A to G, H in the code. And they include at B responsibility to the client, but much wider. And if you look under B, quickly cast your eye down, you will not find, for example, under responsibility to the client, a requirement to exercise reasonable skill and care. You find that under the heading A, responsibility to society. Now, my lord, as it is clear that A1 is a duty which is for the benefit of the client, my submission is straight away you need to be a little careful about drawing too close an inference that merely because the heading says a duty isn't owed to the client, no such duty is owed to the client. And therefore, the learned judge's reliance on the heading at D, in my submission, really doesn't go anywhere near establishing the conclusion reached. But the heading D does, in my submission, point, even as drafted, to the client being a beneficiary in the non-technical sense of the duty. And my submission on this is that the existence of professional indemnity insurance is a selling point for the designer, who is, after all, part of the interior design profession. That's why in my relationship chart I fed that link, top left-hand corner. And it's not only a benefit to the client, it's a benefit to the institute. Why is it a benefit to the institute? Precisely because it's a selling point for designers that they have insurance, it's a selling point that they are members of the institute, which requires them to have insurance. It makes it more attractive for clients to do business with them. But here's the point, my lord. It's only a selling point to the client if the policy achieves the paramount purpose of securing that the insured will have funds available to meet the client's claim. If it's only to benefit the insured designer, it's of no benefit to the client, then it's not a selling point. Now, just back to the chart to see where we are. I've taken you to the provisions of the code. I'm next going to go, it's sort of in point of time, this, because the code was pre-existing, but the next in point of time on this point is Boscolo's letter, bottom left of the chart, of the 4th of April 2013. You find that at page 99. Lordships have that, dated 4th April, addressed to Mr. Vajani, who's in some way connected with my client, I don't know how exactly. And then it's a sales pitch, this letter, none the worse for that. Thank you for inquiry, received the floor plan. Paragraph 2, based on our discussions, I'm confident we can add significant value. You're aware my personal background stems from property development, specialising in high-end residential projects in London. We have a clear understanding of producing such projects, which offers a high-end finish with a modest budget. Now, our involvement will provide a complete turnkey solution with stringent project coordination to manage budgets and timeframes and so forth. And then I said, now too soon. Now, 4th paragraph, to back up our words with some data. First, we are a British Institute of Interior Design Practice member, and our agreement will be based on the conditions of appointment as determined by REBA. And 2, we hold professional indemnity insurance for any one claim and public indemnity insurance for 1 million any single event. So the fact of the policy was being put forward as backup for the sales pitch in the paragraph higher up.
Does the judge refer to this person?
No, my lord, I don't believe so. Let me check. I'm told it wasn't in front of him. Third, the design contract itself. If your lordships go to page 111, this is an extract from the previous page is where it starts, Model Memorandum of Agreement for Interior Design Services, and you'll see on the second page, under Services, provide services as per quotation dated 4th April 2013 for the new revised sum of 11. So there's a link to that sales pitch. It wouldn't matter if there weren't. The sales pitch is still there with its reference, and it makes obvious good sense. But I fear I'm repeating myself. And then, if your lordships would go on page 117. Professional indemnity insurance. This is important. So, requirement in 9.1 to obtain professional indemnity insurance.
Sorry, where are you reading from?
Page 117.
Yes.
Left-hand side, under
Yes.
the heading 9, professional indemnity insurance.
Yes.
The designer shall obtain professional indemnity insurance in respect of the services, not less than the amount stated in the memorandum, that was £250,000. Sorry, the limit was in fact £250,000. Maintain such insurance until the expiry of the period stated. Now, so in 9.2, the designer had to maintain the policy as long as it was available on commercially reasonable rates and terms, failing which, these important words, the designer will inform the client in order that the parties can discuss the best means of protecting their respective positions in the absence of such insurance. Now, my lords, I respectfully submit there cannot be a clearer indication than that in the body of contract itself, but that the clients have an interest in a policy which is for their benefit. Why else would they have an entitlement to inspect, which they've given in paragraph 9.3? But here, the wording of the contract itself recognises that they both have a need to protect their positions in the absence of such insurance. That, in my submission, is utterly conclusive that the purpose of this policy was to secure that the designer should be able to pay valid claims.
Again, you use the word, it shows the client has an interest in the policy. That's not in a technical sense, is it? That's just a colloquial sense against the client is interested in the policy in a colloquial sense.
Well, it means that the policy is being taken out to protect his interests.
Yes, but there's a very strict difference, isn't there, between someone who is an insured or has the benefit of the insurance policy in a technical sense and someone for whose benefit in a colloquial sense the policy is being taken out. And I think you're so far have been submitting it falls into the second category.
I am submitting that the client of the insured is a person for the protection of whose interests the policy was agreed to be taken out. And that, in my submission, is completely consistent with the paramount purpose, namely that it was to secure that the insured would be in a position to meet the client's claims.
What 9.2 is that the designers have to maintain insurance. No, sorry, 9.1. Obtain insurance for not less than the amount stated in the letter memorandum.
Yes.
So the code of conduct is a very general obligation to have carry appropriate insurance. This is specific, and the 250 is the. I mean, it could be 500. It could be whatever. In other words, it's specific to this letter. In other words, the code of conduct doesn't say you must have at least 250,000. No. It's up to
the parties to agree.
It's up to the specific nature of the contract, perhaps, or whatever
yes,
it might be.
But in fact, the position here is that there wasn't a policy specifically taken out for the purposes of this contract. This was a rolling contract.
I understand that.
Yes.
But 9.1 is you have to obtain it. I mean, the fact is they've already got it.
Yes.
But it has to. You have to obtain it. You have to obtain it for the amount stipulated in the letter.
Yeah.
And I appreciate the amount stipulated in the letter is the amount stipulated in the policy that they already have. But it needn't be like that. That just so happens that was the factual matrix in this case.
Yes, it just so happened that that's the way it was done.
Yeah.
And the limit was 250,000 each and every claim.
Yes. Yes.
So the limit available in respect of this contract was 250,000.
Just on a technical point, you say that this contract did specify the limit of the insurance.
I think I should have said it didn't.
It didn't. I mean, the letter you're referring to is not the letter that's incorporated by reference into the conditions.
No, that doesn't. 109.
Sorry, that's the wrong letter. Thank you. 109. I see, because it's referring to a technical document, not just the letter. I was concentrating on the letter. This is the memorandum.
It's Article 11.
Where does it have the 250?
My lord, there is no number. It's Article 11 on page 110. You'll see from the heading on 109 that there were two options, either a letter of appointment or a model memorandum, which is why there's a reference to letter in the conditions. In this case, the model memorandum was used, but there is no figure inserted in Article 11 at the top of page 110.
Right.
But it was the letter which informed the parties, or the client, that the limit of indemnity was 250,000. That's the letter at page 99, which is then referred to in the contract. So, now,
And sorry, just to complete the point, that Article 10 also refers to the. Oh no, hang on. Oh yes, so Article 10 is the period in relation to the designer's obligation to maintain insurance. There's no period specified there either. So Article 10 has a limitation period, and it then says that the period for maintaining insurance shall be the same period, but no period is specified.
I'm very sorry. What page are you on?
It's 109, Article 10.
Yes.
So that's missing.
Yes. If no period is specified, then the period shall be 6 years.
Oh, okay, right. So that's all right.
And so far as the limit is concerned, as I say, that's dealt with in the letter at 99. Now, the designer's receipt of the insurance monies in due course following a claim which was paid to the limit of indemnity was, in my submission, referable to the specific protective purpose, namely to ensure that if the claim succeeded, the designer would have the means to meet it. They were not an asset generated by trading, investment, anything of that sort. They were generated because an insurance policy was taken out which included them as persons who were designed to gain protection from it. And in those circumstances, my submission is there was an implied term of the design contract and the insurance contract that when the designer received insurance purposes, if he had the relevant state of mind, then it would not apply them in a manner which defeated their protective function. I'm paraphrasing, and because it's a familiar objection. Sorry, I'll wait a moment. It's a familiar objection when people seek to imply terms. Oh, you've got to be able to formulate it with precision. You express it in various different ways. My lords, there are many ways to express in words the same concept. So, and in my submission, that's as long as the implied term is one which would be met with an obvious yes by the reasonable, but by the parties on inquiry by the officious bystander, then the term will be implied. Why do I accept the need for the client to have the relevant state of mind? I could say to Lordship, look, it's enough, this is the purpose, when they get the money, then straight away. It's because I would accept that in circumstances that one can imagine, where the insured is a vastly wealthy organisation and the receipt of insurance proceeds are effectively immaterial, to whether or not it can meet a valid claim, that there doesn't have to be a ring fencing in that sense. The requirement for ring fencing arises if, at the time of receipt, the position of the insured is such that unless they're ring fenced, and to the extent they're used for other purposes, the client's claim pro tanto will go unsatisfied.
Now, you talk about this as an implied term. An implied term alone doesn't get you anywhere, does it? Because that's just a contractual matter.
That's step two.
But
step three is the purpose. It's the implied term of the policy and the design contract, which gets you into the shared intention at the moment of payment later on.
I'm not sure you can disassociate the implied term from the whole trust analysis, though, can you? It has to be an implied term, which effectively means the parties have agreed that money should be held on trust.
Well, no, my lord, I say that's not so. I submit that they must have agreed a purpose from which the law can infer an intention to create an equitable interest. In other words, they don't have to say it will be held on trust.
Well, I didn't mean to say that, but they must have agreed something which in law amounts to an agreement to create a trust.
Yes, and well, of course, you can't create a trust at the time of the contract. The trust arises at the time of payment.
Well, yes.
Yes.
Well,
and so if at the time of payment was made for a purpose, namely the paramount purpose, with an implied term that it should not be used for any other purpose, then the law will infer a trust to give effect to that purpose. That's my case.
And is this an agreement that has the consequences of creating express trust?
No, my lord, it's an implied trust. It's an implied term.
Well, the agreements, I don't want to quibble, but the agreement, once you've identified what the agreement is, it contains terms, some of which are express,
Yes.
some of which are implied. Once you've identified the agreement, is your case that this is a trust which arises because the parties have agreed
Yes.
that it shall arise? So
Well,
it's not...
that it shall arise, I don't think quite as necessary. They have agreed that the monies are to be held for that purpose and that purpose only.
I'm just trying to understand, are we in the twin sector arena, or are we in the parties have agreed to create a trust? Create something which the law regards as a trust.
Well, in my estimation, perhaps we're both. The parties have agreed that the monies, let's assume the parties had written, the monies under this policy must be used by the insured only for the purpose of meeting claims. In those circumstances, a trust arises to give effect to that contractual purpose, as long as it's shared by both payor and payee.
The implication of that must be, mustn't it, in order for there to be sufficient certainty for a trust, that it follows that the company is not entitled to use the money for any of its own purposes. It should be segregated so that it can be preserved for that purpose.
That is why that's where the relevant state of mind comes in, because it's part of the agreement that it should be triggered by the relevant state of mind. If the relevant state of mind exists at the moment of payment and receipt, then the contract says in those circumstances, purpose. Yes, and therefore, and we say as the relevant state of mind had arisen, therefore the trust arose. And the reason why the relevant state of mind is required, because absent those circumstances, there would have been no need to ring fence. And the parties wouldn't have intended that they should be. My lord, I can no longer watch your lordship's pen.
Carry on.
I was now going to turn just to a different point. It's probably slightly out of order, but that's in my notes here. I will go to it. This is just the point that on receipt, and the date of receipt is approximately 19th August 2021, Boscolo had the relevant state of mind. And the learned judge touches on this. If you go, please, to page 72. This argument wasn't before, but still something relevant to it. In paragraph 7, no, sorry, paragraph 9, events after claim notified. Learned judge says, in the usual way, the policy provided for insurers to take over and conduct the defence, so forth. And then the next sentence in the fourth line. On 4th March 2019, the respondent's claim is formally denied by DAC. By that stage, at least, it is clear the company was in financial difficulties. Company's unaudited balance sheet for 31st March, approved by Mr. Lepkani, who's the principal of, was the principal of Boscobel, 20th December 2018, showed a deficit of total assets to current liabilities of nearly £300,000. That figure includes a director's loan from Mr. Lepkani, tell your lordships. Thereafter, no, sorry, we don't need to read on from that. And I can just give your lordship for your lordship's notes, but you don't need to turn it up. But the accounts for 2018 showed a net deficit of £229,000 odd pounds. That's on page 164 of the bundle. The 1919 position is shown at page 170, and it was a deficit of 260. And the 21st January 21 accounts for the period ended 31st March 2020 showed a deficit of 245. See that at page 172 of the bundle. The reference for the payment of the insurers by the insurers of the limit of indemnity of 250,000. That's A 174. And then the statement of affairs signed by Mr. Lepkani, which is 20th October 2021, that is bundle pages 181 to 3, shows cash at bank £246,000, which is what's left of the monies paid by insurers. And so, as a matter of fact, the monies have actually been in the segregated account ever since being paid, and they're now in the hands of the liquidators. And the statement of affairs show preferential creditors nil, unsecured creditors just under £300,000, and the principal unsecured creditors were Mr. Lepkani, £250,000, and my clients, stated as £250,000. And I understand that the reason for £250,000 is because, on at least the liquidator's case, maybe Mr. Lepkani's case, there was a limitation provision in the contract which limited their liability to the limit of indemnity. But in my submission, it's clear beyond argument in those circumstances that Boscobel must have had the relevant state of mind as described in my ground, or I think at the time of receipt.
Yes.
So, my lords, if I may now go to deal with the question how the trust arises. And just make a couple of jury points at this stage, which is that in circumstances where there's a claim outstanding, which has sufficient merit that the insurers would rather pay out the limit of indemnity and wash their hands than fund proceedings, so that the company receives 250,000. It would, in my respectful submission, be regarded as outrageous if those monies were to be used to pay off the director's loan. And I'm factoring into that point that it was the paramount purpose for which the insurance contract came into being, to secure the position of the client in relation to his claim. And that to allow the monies to be used for an extraneous purpose would completely defeat that purpose.
Not completely, would it? I mean, the company without this insurance payout would have had no funds to pay any of its creditors. So what it has, because of this insurance payout, is funds with which it can pay its creditors, including the appellants.
Well, but my lord, the policy wasn't taken out to benefit other creditors. Its paramount purpose was to secure the position of the client who had made the relevant claim. Yes, I accept there were other purposes, and other purposes included that it would be a boost to the assets of the claimant generally in certain circumstances, and he paid the claimant client. Well, then there are more assets available for other creditors or for the business's own purpose, but only after he's paid the claim which gives rise to the payment. So, Lords, I'd sort of pose the rhetorical question, why is it fair that the monies intended to secure the position of the claimant should, when received, in circumstances where it was known that using them for other purposes would frustrate that paramount purpose? Why should the law say, well, it's fine? The person whose claim gave rise to this payment pursuant to a contract, the paramount purpose of which was to protect that claimant, nevertheless will omit the monies to be shared with the other unsecured creditors. It's kind of salt in the wounds that the other unsecured creditor is in fact a director who's made a loan. the person indeed who wrote the letter of the 4th of April identifying the attraction of dealing with his company because it had indemnity insurance. But my case is obviously broader than that. So, my Lord, conscious that your Lordships asked us to identify the Angove case, and I was going to say something about that briefly. I don't know where your Lordships have it in the bundles, whether in mine.
I think I got it handed up, but maybe you got it handed. You got it. You got it too. Yeah. Yes, it's all right. We've got it. Thank you.
So, my Lord, Angove was a very different case. The assumption explains briefly, paragraph 2. A winemaker selling wine via an agency, under an agency agreement. And there are 2 sections of the judgment. It deals with the question of revocability of an agent's authority from paragraph 6 onwards. Don't think we're concerned with that. And then it deals with the question of trust at page 587.
Yes.
It's strictly obiter, but obviously entitled to the greatest respect. And Lord Sumption says it's well established the duty.
Sorry, which paragraph?
Paragraph 19.
Yes.
An agent has a duty to account to his principal for money received on his behalf. It's, however, well established that the duty doesn't necessarily give rise to a trust of the money in the agent's hands. That, says Lord Sumption, depends on the intentions of the party derived from the contract, or in some cases from their conduct. And we, of course, respectfully agree with that, and that indeed is why we say trust arises in this case. As a broad generalisation, relations between principal and agent must be such that the agent was not at liberty to treat as part of his general assets money for which he was accountable to his principal. This will usually, but not invariably, involve segregating it from his own money. And I understand Lord Sumption to be saying that as a broad generalisation, in order to give rise to a trust, the relations between principal and agent must be such that the agent was not at liberty to treat as part of his general assets money for which he was accountable to principal. Now, in our case, translating that to our facts, we say the arising of a trust depends on the intentions of the parties derived from the contract, although we say there are 2 relevant contracts here, not merely one. And as a broad generalisation, relations must be such that the agent was not at liberty to treat as part of his general assets money for which he was accountable to his principal. Well, in our case, we're not concerned with accounting to a principal. We are concerned with, and in my submission, the position is that the insured was not at liberty to treat as part of his general assets insurance monies referable to a claim by a client in circumstances where he had the relevant state of mind, but must use those monies only for the purposes of the contract.
So it's definitely not a case where the company was not entitled to treat as part of its general assets monies referable to a client claim unless and until the relevant state of mind cuts in.
That is what I accept, yes.
So rather like the payments in the Neste Oy case, which the Supreme Court overturned in this decision, at least overturned, there were 6 payments, 5 of which there was no trust, no quis clos trust, no express trust. The agent kept them for himself. But by the time of the 6th payment, when the agent had something which is akin to the relevant state of mind in this case, Mr. Justice Bingham, as he then was, said, well, then a trust is imposed then. That's what you would, similar to what you're saying here, isn't it?
Well, I'm not sure that went well for Mr. Justice Bingham.
No. Well, what's the difference?
Well, the difference is, and I mean, plainly, I was more going to say that the facts are different, but in my submission, we are not an instalments case. We are a one-off payment made for a specific purpose. And that, in my submission, means when the relevant state of mind occurred, and when subsequently that payment was made, a trust arose. And my lords, the fact that the contractual intention is looking forward to a time of payment, and that intentions are imputed at the moment of payment, makes no difference. It would have been exactly the same if let's suppose the claim had been made and either admitted or established, and the monies were then paid, and the recipient had the relevant state of mind. Again, it was a fortiori, the trust would arise. And if I can go on to paragraph 25, where Lord Sumption starts to deal with what he calls the fundamental objections to the constructive trust proposed by Angos. At the time when the money was paid by customers to D&D, it was not impressed with any trust in favour of Angos. If therefore constructive trust came into being, it did so for the first time on its reaching the hands of the payee. But in our case, when the monies are received by Boscolo, they are impressed with a trust. And it's very important, and I accept that there could be no question of trust if at the time of receipt Boscolo did not have the relevant state of mind. And it wouldn't matter that subsequently, and before disposing of the money, the relevant state of mind arose, because you can't have shifting equitable interests in that way. The money has to be impressed with the trust at the moment of payment. And so, in paragraph 27, Lord Sumption quotes from Lord Brown Wilkinson, I think in the West Deutsche case, under an institutional constructive trust, the trust arises by operation of law as from the date of the circumstances which give rise to it. The function of the board is merely to declare that such a trust has arisen. And that is our contention in relation to receipt of the money by Boscolo on payment by the insurers. And certainly, as I read what's being said in relation to the Neste Oy case, that wasn't a case where a trust arose by reason of the purpose. And indeed, in describing Mr. Justice Bingham's decision, at letter G, Lord Sumption points out that Mr. Justice Bingham had declined to find that the payments were subject to a special purpose trust. Now we say they are. These monies are subject to a special purpose trust because of the paramount purpose. And therefore, in my submission, again, contrary to our position, concluded that the recipient was entitled to treat them as part of its general assets. And then, when Lord Sumption goes on in paragraph 30 to say the exact circumstances in which a restitutionary proprietary claim may exist is a controversial question, giving rise to a considerable body of judicial comment and so forth. But for present purposes, it's enough to point out that where money is paid with the intention of transferring the entire beneficial interest to the payee, but my lords, that is not our case. We say that there was no intention to transfer the entire beneficial interest to the payee. The intention was to transfer the monies subject to a requirement, if the recipient had the relevant state of mind, on receipt, that they were to be used only for the purpose for which they had come into existence, namely to secure that the company had funds to meet the client's claim. Now, I accept then that if, in other circumstances where the intention is to transfer the beneficial interest to the payee, then for a trust to arise, the intention has to be vitiated. But none of that is relevant in our case. My lords, I went quite fast through here, which means I'm doing well. Just going to check a couple of points.
We'll take a 5-minute break. It's getting quite hot.
I'm obliged.
And if somehow the door could be open so that we might get some air through or
Yes.
something, that might be helpful. So we'll be back in about 5 minutes.
Too hot. I'm just trying to see if we can find something to keep warm. You could do a chair that one. Books. Got many books. Yeah, that's true. Some of these are pretty heavy. Yeah. That will do. That's a good for a start. Yeah. Steady. Oh, there we go. Yeah.
See what the law of physics says.
Not even these heavy books.
I did one by the judge of the law.
Yeah.
You need a wedge.
Thank you. Yeah, unfortunately.
Especially when you need 2 wedges.
Yeah.
I think that might be alright. Yeah. Alright, yeah, hopefully. We've opened the one.
Yes.
Right from the just to pick up a few points. I should say an awful lot of my learned friend's skeleton is accepted by us. I perhaps might try and highlight some of the key points of where we don't accept things. I'm not trying to get my retaliation in first, but it may help if my learned friend is able to take account of those points and then shorten my reply. First, at paragraph 23 of the learned friend's skeleton, page 48.
Yes.
She says, sorry. Yes. It's the very end, I'm sorry, of paragraph 23. She says, the company was at liberty to continue its defence of the claim, and unless the appellants are correct, it was entitled to use the payment in order to do so. So, what learned friend appears to be understanding me to say that on payment of the insurance monies, they were not at liberty to use those monies as defence costs. That's not my case. And this is why I said the paramount purpose is not the only purpose. There are other purposes, and so it's a little more subtle than merely on receipt of the monies with the relevant state of mind. The claimants are entitled to receive those monies, because I hope I've always made clear in my submissions that the entitlement to payment does depend on establishing the claim. And it was a purpose of the policy that money should be available to defend the claim. That it would be subject to an obligation or requirement. The defence must obviously be in good faith. Subject to that.
So would that cover, for example, where the company does go into liquidation after the payment's been made, the funding of a liquidation, because the agreement or adjudication of the claim will primarily take place within the liquidation. It may be proceedings are allowed to continue at some point, but absent that, the liquidator makes its own investigations. Is that all covered by the trust? They can use the money for that purpose?
I wouldn't like to accede to that proposition. At the moment I'm focusing on a slightly simpler one, which is where there's a claim made, as indeed in this case. A claim has been made, proceedings have been issued, and they've been stayed pending the outcome of this application. I can certainly see that it could make sense for liquidator's investigation into the merits of a claim to be considered as part of defence costs.
But coming back to your point, how does it benefit your clients if the insurance monies are all consumed defending the claim?
It doesn't.
So what's the point? What's the point?
Well,
what's the point if there's no benefit to your client?
Well, if monies are paid, and part of the purpose is they can be used for defence costs, if the unhappy consequence is that all of those monies go in defence costs. Maybe even before the claim has been adjudicated upon. That's most regrettable. But I can't...
How can you have a trust in respect of what may be £0?
Well, no, my lord. The trust bites on the monies in the account.
But you're accepting there's not a breach of trust for the monies to be expended on defending the claim.
Yes.
So you're
In good faith.
Right, okay, but no suggestion otherwise. So your clients are claiming a trust in respect of a pot which may amount to 0. Don't understand how that works.
Well, at the moment it doesn't amount to 0. If and the trust is that it should be used only for the purposes for which it's been paid, which include good faith future defence costs.
All right.
I sense I haven't addressed your lordship's concern, but at any rate, I have accepted that they may be used for defence costs.
Can you point to any case in which a trust has been held to exist in respect of a wasting asset which may waste to 0?
Well, I can think of an asset which might be in such a condition. For example, a house which is in the course of being blighted, maybe has been blighted. Its value may be 0 for that reason. That doesn't of itself deal with the existence or otherwise of a trust.
All right, I think my question is ill-phrased. Let me try and phrase it better. An asset which may be expended on non-trust purposes so as to reduce it to 0, or for purposes other than those of benefiting the beneficiary so as to reduce it to 0.
Well, no, I mean, the straightforward answer is I can't think of a case which has those facts. But in my submission, that's not a reason why a trust may not be imposed on monies that's subject to a proviso that those trust monies can be used for specified purposes which were within the purposes which gave rise to the trust. And the existence or otherwise of the trust at the moment of payment cannot depend on the question whether, by reason of some events which may occur after the moment of receipt, those assets cease for one reason or another to exist. So, trust comes into effect in respect of property. It's immaterial for these purposes what the value of that property is. So if it's valueless, people are hardly likely to be interested in arguing about it. So, my Lord, next I was going to pick up some points made at paragraph 41 of my learned friend's skeleton argument. You can find that at page 54. And a number of objections are made. Well, indeed, here she poses the question that I've just been dealing with in relation to defence costs. So, she asks at paragraph 41(2), unclear whether the company is entitled to take account its own view of the merits or quantum of the claim, so forth. In my submission, this is simply a question of fact as to what view they take, but they are entitled, the liquidator would be entitled to take account of his own view. The objection at paragraph 41(3) that suspicion is a subjective and imprecise term and a low bar. My Lords, in my submission, suspicion, reasonable grounds to suspect, is a perfectly respectable concept to impose as a condition, rise as a condition for many, having many legal consequences. And there's no problem with the inclusion of that wording in an implied term. And the point at paragraph 41.5, there's no the suggestion that the term that we contend for and the trust that we contend for may grant my clients a windfall. I don't know. We accept that the company is entitled, in good faith, to contest the claim. Same point in relation to 4.17. My Lord, 41.8 suggests difficulty if there are a number of claims arising out of the same conduct and so forth. Well, Lords, those difficulties would simply have to be dealt with and addressed in relation to any case in which they arise. These are all hypothetical points. And with respect, given that we are concerned only with insurance monies that are the proceeds of an insurance policy which responds to my client's claim, in my submission, it's hard to see, it's impossible to see how these kind of points could arise.
Well, it goes to the terms of the trust you rely upon. So if another claim was intimated to the company by someone else, the day after...
Do you mean another client?
Another client, yes. The day after this money was paid to the company...
But that would be a separate claim.
Well, it would indeed.
And it would have a separate limit.
No, indeed. But there's no payment in respect of that. A claim's intimated.
Correct.
Do you say the company cannot use this money to investigate that claim?
He can only use it, the company can only use it to investigate this claim and defend this claim. He cannot defend it. He cannot use this money for purposes extraneous to the purpose for which it was paid, his other claims. Now, my Lords, I haven't taken you to impact financial. Perhaps I should do so. that case begins at page 367 of the, beg your pardon, page 141, tab 6 of the authorities. And in terms of the composition of the tribunal, Lords Mance and Sumption agree with Lord Hodge, as does Lord Toulson, and Lord Carnworth dissents. And from the head note, the extent of an insurer's liability can be ascertained by reading the statement of cover together with exclusion clauses, and was not to be approached with a predisposition to continue narrowly, but rather to be read in the context of the contract as a whole and construed in a manner consistent with the purpose of that contract. And a few lines down, it was so obvious that it went without saying that the policy in question required to be interpreted against the regulatory background of the compulsory professional indemnity insurance scheme which Parliament had authorised and the Law Society operated, and which existed principally to ensure that the public who used legal services were not compensated for a solicitor's failure. Now, the only part of that overall proposition which is different from my case is the fact that it's Parliament who'd authorised and the Law Society who operated the scheme, and that it related to legal services and a solicitor's failure in duty. And so we rely on the principles that PII policies is to be read in the context against the background, of course, and the distinction that it's the solicitor's policy with pursuant to a statutory scheme, we say, is a distinction without a difference, and lawyers are not a special case. And so paragraph 16, page 147, Lord Hodge quoting Lord Brightman, describing the context of the statutory scheme of compulsory insurance in exercising its power, Law Society performing a public duty and so forth. Scheme is not only for the protection of the premium-paying solicitor against the financial consequence of his own mistakes, mistakes of his partners and mistakes of his staff, but also, and far more importantly, to secure that the solicitor is financially able to compensate his client. Now, so this shows at least the twin purpose of protecting the solicitor, or rather, the purpose of protecting the solicitor and his staff and so forth, but far more importantly, to secure the solicitor is financially able to compensate his client. And I have yet to see any meaningful basis on which the same is not true of the policy in this case. And Lord Toulson, with whom Lords Mance, Sumption and Hodge agree, and paragraph 41, page 152 of the authorities. As the third line, as the House of Lords recognised in Swain, the paramount purpose of the Law Society being given statutory power to require solicitors to maintain insurance cover against professional liability was the protection of that section of the public that makes use of the services of solicitors. So that's actually where I think I took the phrase paramount purpose from. And I recognise that what's being spoken about is the purpose of the rules, but you can't dissociate the purpose of the rules having that function from the purpose of the policy which is made pursuant to that function. And important to appreciate that this statement of the law was not available to the Court of Appeal in Harrington. And in my submission, it fundamentally undermines the reasoning which led the Court of Appeal in that case to reach the conclusion it did. I might perhaps very quickly go to Harrington. In its tab 1 at page 4 to 5, start at page 5, up at the top, Lord Hanworth says, no direct privity between debenture holders or principal debtor on the one hand and the insurance company on the other. And then a few lines down, it's actually 5 lines down after the break, sentence begins, as I've said, Mr. Chaplin's action for execution is stopped by the bankruptcy. He then has a right to come in and prove in the liquidation. But what is the right which the liquidator has to receive this money? It's not really true to say that it's due to the action of Mr. Chaplin. The occasion of the loss in respect of which the insurance money is paid over is that Mr. Chaplin suffered an accident in the street. But the reason why the insurance money is paid to the liquidator is that over a period of time, the company, now represented by the liquidator, have made an independent contract of their own and paid their own money to the insurance company so that if and when a liability on their part arose, there should be paid to them a certain sum of money. Now, there's no recognition in that part of this judgment of any legitimate interest of Mr. Chaplin in that money. Phrase, independent contract of their own. And then, supposing the defendants in the action were solvent, then the money would have been paid out of any sums which the defendants liked to appropriate to that purpose. They need not pay over the actual sum received from the insurance company. They could pay out of their own resources in such way as they pleased. Fine, if there's solvency. But then, does the bankruptcy give any fresh right to the creditor to follow through the bankruptcy, the sum paid in respect of this loss by the insurance company to the debtors? Basically, that cannot be maintained. There's an absolute break in the relationship between the creditor who has suffered the accident and the insurance company. There cannot be a privity under which, when the bankruptcy supervenes, you can cancel, but the defendants, and then say that a privity arises between the creditor and the insurance company. And then a little further on, it's therefore clear to my mind, after considering the nature of the bar to the further proceedings, namely bankruptcy, there is an absolute break in the relation or suggested relation between the creditor and the insurance company. Now, it's that which we say is that reasoning is undermined by the explanation by the Supreme Court and the House of Lords of the paramount purpose. There's not an absolute break. It is a paramount purpose that the insurance monies are to be available to secure that the insured has money available to meet the claim. And, of course, wholly absent from the facts in Harrington are the connections between the insurance company, monies, insurance policy, and the clients under the design contract with the PI, professional indemnity policies. And the element of the policies being used as a means to persuade clients to contract. And the expression of unhappiness by Lord Justice Atkin, bottom of page 6, I'm of the opinion that the applicant has a real grievance, and if it were possible to decide for him, I would very willingly do so. Well, after going through the circumstances and after quoting the liquidator's response, no, that sum of money has now become the general assets of the estate and so forth, as I say, it seems to me that discloses a hardship. And then the position in law seems to be clear that a third party has no claim in law or in equity then is sought, or against the money paid by the insurance company. Amount is received as part of his general assets. There's a general rule of expediency of that I can't think can be disputed. It would obviously disturb the whole practice of insurance if the claimant against the assured if the claimant against the assured who caused the risk had a direct right of recourse against the insurance company, and we know in actual practice the assured receives the money, parties being solvent and so forth. And then Mr. Stable, in his interesting and able argument, admitted that apart from insolvency, the third party has no sort of right in equity against the insurance company under the policy. I find it impossible to see how a special right arising out of the circumstances which ordinarily occur in cases of insolvency could come into existence merely because the assured happened to be in difficulties or financial weakness. And but, my Lord, nowhere in the argument that's put forward is there the point that the insurance monies derive from a tripartite contractual situation. Say 3 parties, 2 contracts, purpose of both contracts, and an implied term of both contracts, that monies were to be used for the paramount purpose when the relevant state of mind had occurred.
And this is completely different because there was no contract between the Mr. Chaplin and the taxi company.
That's correct. And so
It's purely about the terms, the effect of the insurance policy held by the taxi company.
yeah, exactly so. And then what one sees, bottom of page 10, Mr. Zatkin comes back to this being, he says, it's very striking, his wording. This is on page 10, 4 paragraphs from the bottom. I agree that on the whole, this is an unsatisfactory result of the application of legal principles which are very good in themselves, which I should like to be able to modify to meet the special facts of this class of case, which is a very common one. Well, Lord, one has to ask, if the application of legal principles is leading to an unsatisfactory result, is that because the right principles are not being applied or not being applied in the right way? But at all events, in the very different circumstances of this case, there is in my submission a clear route, your lordships, to find, applying good legal principles, a way to vindicate the paramount purpose and prevent it from being defeated by a, what I would respectfully submit, it would be an inflexible desire, wish to follow the ordinary pari passu rules in insolvency, and not recognising that the pari passu principles should operate so as not to interfere with the prior consensual basis of all concerned as to the purpose for which monies are to be paid to a party. Now, that, I think, for the moment, is subject to any other points your lordship may wish me to develop in the few minutes left.
Do you have any questions? Do you have any?
In which case, I'll sit down and then
Okay.
I'll resume a little earlier than I would have.
Thank you very much. Yes, Ms. Chalmers.
My lords, the key issue which we're being asked to consider today is whether or not the appellants have a proprietary interest in the sum of money that was paid to the company by its insurers. And in principle, that's quite a wide question, which you'll appreciate can arise in a very varied manner of situations. In effect, there, we say, are two separate strands to the appellant's argument, which are then joined together. The first is that they say that their interest can be derived from the terms of the contract of engagement made between them and the company. But they also say, and this is perhaps maintained but less well explained, that their interest can be derived from the terms that have been agreed between the company and its insurers, and or the terms upon which the payment was made by those insurers to the company. Turning first to the contractual relationship between the appellants and the company, we would suggest that there are really three issues for the court to consider. First, what are the circumstances surrounding the payment to the company by insurers? Secondly, should a term be implied into the contract as to the use by the company of that payment? And third, if so, is a trust created in equity in support of those contractual rights? We would draw a distinction, I think, between two factual scenarios. The first is a case where the claimant's claim has been determined by judgment or compromised, for example, by insurers exercising their rights under the terms of the policy. Payment is then made by the insurers in respect to the sum that is payable by way of indemnity under the policy, but the payment is made to the company and not to the appellants directly. In those circumstances, we would submit that the only implied term that the court would be considering is an implied term that the company should pay to the claimants the sum that had been received from insurers by way of indemnity in respect of its liability. And that, of course, was the factual scenario in Harrington, but it doesn't apply here, as my learned friend has accepted. Here we have scenario 2, which is the claimants have intimated a claim against the company. It has been notified to insurers in the usual way, and it's a claim in respect of which cover under the policy may respond. But the claim hasn't been determined or compromised. Nevertheless, a payment has been made by the insurers to the insured. Now that could have been by settlement of the insured's claim under the policy, for example, if there was a dispute as to the applicability of the policy or whether it could be avoided or whatever, or as in this case, pursuant to a term in the policy which permits the insurer to make a payment in lieu of its obligations, both to indemnify the company in respect of its liability if that's determined in the future, and to defend the claim. In the course of this litigation, the appellants have suggested a number of different alternative implied terms, and it's fair to say that the case that is being pursued before you today is a very different one to the one that has been pursued initially, correspondence, in the court below, and indeed at any time until I was notified yesterday of the amendment to the grounds of appeal. And indeed, in fact, I would say that there's been a further concession by my learned friend today. I would ask respectfully that the court does make reference to that in the judgment for this reason. Whilst obviously today the focus is on the case that's now being presented, it's important not to lose sight of the background to this case and the reason why we're here. And the reason why we're here is because there was a claim both against the company and against its insurers, which is currently stayed in the business list. You can find the particulars of claim, they're in the supplemental bundle, I think at page 196. Sorry, 193 they start. And that claim is for seeking several separate remedies. It's a claim for knowing assistance in breach of trust against the insurers, is a claim for immediate payment of the sum of £250,000 received by the company, and there is an additional claim for damages arising out of the underlying events which gave rise to the claim in the first place. This application was made because those proceedings were stayed and at an impasse in circumstances where the company was saying that it had an immediate right to that £250,000 and the liquidators were unable to do anything about investigating or defending or dealing with that claim at all. I don't need to take you to it, but for your reference, page 202 in the bundle is a witness statement from Mr. Cullingford, solicitors engaged by the liquidators, and he sets out at paragraphs 38 and onwards, page 211 in the bundle, the chronology of events that took place. And suffice it to say, all of the correspondence underlying that is not in the bundle because it's not necessary, that the liquidators have been maintaining throughout the claimants have been maintaining throughout that the liquidators have not been entitled to investigate or access the funds in any way, to carry out any investigations into the underlying claim, to defend the underlying claim, to administer the assets of the company, or indeed to do anything at all with that sum of money other than paragraph 46 of his witness statement, to pay the entirety of the cash fund to the claimant. And that position was maintained before the learned judge, His Honour Judge Matthews. That was the only implied term which the learned judge was being asked to consider. The implied term being there's a trust of this £250,000 and it should be paid immediately to the appellants. It was the only basis upon which the appeal was originally advanced, and then it has been subsequently amended. The position we have now is that the case is that there is a ring-fenced fund. It doesn't have to be paid to the appellants, but there's a ring-fenced fund which cannot be used for any purpose other than, and here in my respectful submission there has been a change. The focus of all of the submissions to date has been that it could not be used for any purpose other than to meet the liability that the company owed to the claimants, and that was the purpose for which it was ring-fenced. In my submission there has been in effect a concession today that that doesn't make sense when one looks at the wording of the policy that I'll take you to in a moment, and therefore the appellants say the company can access the fund to defend the claim against it, to investigate it and so on. And we would say that once you reach that position, it is evident that that's why the trust analysis doesn't work and must fall away. Because at that point, it becomes almost impossible to determine when and if a trust would arise, what the subject matter of that trust would be, or indeed who the beneficiaries might be. And we would say that those are all very good reasons why there is no trust, and there is no reason to interfere with the existing principles as to the allocation of resources by a company that has gone into liquidation. We do say that in relation to scenario 1, the actual payment in respect of an actual indemnity, which is liability which has been determined, there probably is an implied term of the contract that in those circumstances the company receives a payment from its insurers in respect of a claim which has been proved by the claimants, that they should pay that money on to them. We would say that Harrington remains good law in that the trust doesn't arise, there's no fiduciary obligation upon them to do that. But it does seem to us that, in fact, in relation to the particular circumstances of that case, which we don't have to consider for today, it may well be a case where a twin sector analysis might have moved matters forward if the insurers are settling a claim and then they pay to the company instead of paying direct to the claimants. It may well be possible to say, on a particular set of circumstances, that the insurers have made that payment for a particular purpose, namely to extinguish their liability to indemnify in respect of that proved claim. And therefore, if the company didn't make that payment, then a resulting trust might arise. But that's a completely separate analysis. It doesn't arise in the context of the current case.
Why does the payment by the insured to the claimant, extinguish or not extinguish, have any effect on the insurance claim?
I'm not sure that one could see, when one could envisage a situation where the insurers have settled the claim, they've agreed to pay the claimants £100,000, and then for whatever reason, by accident or whatever, instead of simply paying the £100,000 direct to the claimant's solicitors, they paid it to the company.
Oh, because the insurer would pay the claimant?
Yes, because the insurer would normally be paying the claimant. And one can see that in that specific narrow set of circumstances, if for whatever reason, instead of paying the claimant direct, that sum of money was paid to the company for the purpose of meeting the agreed settlement sum, one can see that in those circumstances, the insurer might be saying, no, I only paid you that money by mistake or for onward transfer to the claimants. You shouldn't be able to retain it. But that is a completely separate set of circumstances which simply doesn't arise here. It might go a little way to address the particular vice that the court was concerned with in Harrington. But we would maintain that even in that set of circumstances, there's nothing that we can see in the current law that would suggest the arrangements between the company and the claimant, i.e. that contract, the design contract, gives rise to a fiduciary obligation. If there is a fiduciary obligation, it only arises out of the circumstances in which the payment was made and not out of the underlying contractual arrangements between the parties. Here we have scenario 2. There is no agreed payment, and we say in this situation there is no implied term because the necessary requirements are not satisfied. And even if there were an implied term, then a trust would not arise, and the learned judge was right to find that the payment as a result does become part of the general funds of the company, as the learned judge found. So we say then that, turning to the first question, what are the circumstances in which the payment was made? It is, in my submission, sensible to briefly look at the terms of the policy. I should be able to deal with this relatively speedily because, of course, to a large extent they're set out in the judgment, although in fact the judgment does not recite the key clause, which is the one pursuant to which the payment was made. The schedule is at page 132 of the supplemental bundle. And one can see from that that this is a composite policy covering professional indemnity cover as well as, for example, public liability. The limits of indemnity include £250,000 any one claim in relation to professional indemnity. And then going on to the policy wording, which sets out the obligations of the insurer. The definitions are important, page 139.
Sorry, 149.
139.
Oh, sorry, 39. Thank you. Yes.
Claim within the meaning of the policy is defined widely. Of course, it includes, as one would expect, any notification either of an intention to commence proceedings or a written communication asserting a legal liability.
Yes.
And you'll see there that there's a reference to the definition of defence costs. Defence costs being all costs and expenses associated with the defence and investigation or settlement of the claim. And that, of course, includes in connection with any circumstances which might give rise to a claim. So, in other words, investigation before the insurer even knows whether the claim is covered under the policy or not. The insuring clause is at page 141. And you'll see there that the limit of indemnity includes liability for the claimant's costs and expenses.
Sorry, where's that?
Paragraph 1, civil liability. The insurer will indemnify the insured up to the limit of indemnity in respect of claims first notified during the period of insurance, being a claims made policy, in respect of civil liability, including liability for claimant's costs and expenses.
And then in addition paid defence costs.
That's right. And you'll see there that there's in fact a qualification to that, in that if the defence costs won't be payable in full if the claim itself is disposed of for a sum which exceeds the limit of indemnity, presumably on the basis of contribution from the insured. And in passing, I note also on page 141, you'll see there the limits of indemnity. and it's made plain there that there is one limit of indemnity in respect of all claims attributable to the same act, error or omission or series of acts, errors or omissions consequent upon the same original cause. The relevant clause in relation to this case is claims condition 7, which you find on page 144. In connection with any claim against the insurer may at any time pay to the insured the limit of indemnity after deduction, effectively, of any sums that they've already paid, or any less amount for which such claim can be settled. And thereupon, the insurer shall relinquish the control of the claim and be under no further liability in connection therewith, except for defence costs in respect of which the insurer may be responsible in respect of matters occurring prior to the date of such payment. So in effect, this clause is a way in which the insurer can meet their obligations under the terms of the policy without indemnifying the insured at all.
Can I just ask about the interplay with the Third Party Rights Against Insurers Act? It's common ground, it doesn't apply. As I understand it, that's because this payment was made before liquidation. It would have applied had the liquidation happened a month earlier.
The way I read it, an insurer would not be able to rely on that clause, apart from possibly to pay the sum to the appellants.
Before you get to that, is it common ground that the only reason the Act doesn't apply is because of the timing? Yeah. So then the next question is, clause 7 presumably couldn't be operated because the right to transfer.
It couldn't be operated unless, I suppose, that sum of money was paid to the claimants, but it doesn't matter what the background is. The problem in this case is because the limit of indemnity includes claimants' costs. And in effect, that clause is there to assist insurers that, for whatever reason, find themselves in a position where they don't want to carry on defending the claim. Now, that might be because they can't settle it within the terms of within the scope of indemnity. It might be because the claim is so vast that the limit of indemnity is simply a drop in the ocean, and they just don't. There's no point in them carrying on dealing with it. If it's a £5 million claim, they may say, well, look, our costs of defending this are vastly going to exceed the £250,000. Have it, and we wash our hands of it. And you'll see there's the reference to the fact that it may be a lesser amount where the claim can be settled for that amount. One can see that there might be a situation where, for example, the insured is refusing to allow the insurers to settle the claim on terms that they consider to be reasonable. So there are lots of different factual scenarios in which insurers rely upon that condition. It's in most professional indemnity and public liability policies for that reason, but the purpose of that clause is not to help the insured. In fact, in effect, it's depriving the insured of the primary benefits that it would like to have under the policy, i.e. an insurer who is going to deal with the claim, investigate the claim, meet the defence costs on top of the limited indemnity. So it's actually adverse to the interests of the insured, and it's certainly not there for the benefit of the claimants either. It's just there for the benefit of the insurer.
So if there's a liquidation looming, the insurer might be incentivised to operate this clause if it couldn't do it after liquidation.
I was going to deal with this later, but I can deal with it now. It's right to say that in relation to most of the compulsory insurance schemes, either they expressly prohibit that clause, for example, under the solicitor's indemnity rules, that sort of clause is prohibited, doesn't exist, or in some schemes, for example, the motor policies, it's dealt with in another way because the insurer remains under an obligation to indemnify. And so even if the insurer were to pay out under a clause like that, it wouldn't obviate their obligation under the Road Traffic Act to meet the claim in any event, so there'll be no point. So by various different means, Parliament has already, either directly or by delegated authority, put in place measures to protect claimants in specific cases where it's considered inappropriate. And they are generally in the context of a statutory scheme which has been set up for the purpose of protecting innocent claimants. And in passing, I would mention, of course, that the fact that there's been a payment under that clause doesn't imply anything about what the insurers think about the merits of the claim. It just means that they don't want to deal with it anymore. We would say that that clause is a clause which is inconsistent with any implication into the terms of the insurance policy of a term to the effect that that payment should be dealt with in a particular way, for example, by way of payment only to the claimants. It's not its purpose, and if that's what it was saying, it would have said it. It's not. It's simply there. It's enabling the insurers to wash their hands of the claim. And so, just for your reference, at page 174, there's the letter from Royal Sun and Alliance of the 19th of August of 2021, setting out the insurer's intention to make that payment. And on page 175, the insurers say what the consequences will be. On making the payment, your insurers will have no further liability in connection with the claim. In other words, your insurers will be released and forever discharged from any further liability to your company in respect of the claim under the terms of the policy. Also, when making the payment, your insurers will relinquish control of the claim. We will therefore cease to act on your behalf, and further, you will be responsible for all defence costs from the date of the payment. And in fact, the company went back to check whether their understanding was correct. Page 176 in the bundle. The bottom of the page, the email from the company. The policy and your correspondence to the company regarding RSA's decision to dispose of the claim have been silent on how the company is required to treat those funds. Can you please confirm the terms on which the payment was made to our client? Are there any restrictions on use? And the response, it's been made in accordance with Claims Condition Clause 7. The only references regarding the payment is that insurers relinquish control of the claim, doesn't dispose of the claim, contrary to the statement in your email, and it discharges any further liability our insurer client has in connection with the claim. There's nothing in the insurance policy to take matters any further, we would submit. The insurers would have known of the clients of the company in general terms as a class of potential claimants in respect of the liability under the policy. Of course, the policy extends beyond liability to clients to anyone who might have a claim against the company in relation to the risks that are insured. But there's nothing anywhere to suggest that the insurers were aware of the company. They certainly hadn't been noted under the policy. They're not beneficiaries under the policy. There's nothing to distinguish them from any other professional indemnity policy. The next issue is a separate one, which is the question of implications of terms, and noting that the time is just before 1 o'clock, I wondered whether that might be a convenient moment.
Yes, indeed. So we will start again at 2 o'clock.